Good day. Our topic for today is about extinguishment of obligations. We had talked about in our previous lessons the meaning of extinguishment. And when an obligation is extinguished, it means the obligation is already cancelled or it is already erased in such manner that there are no more rights or obligations that will ever arise or confer or be conferred on any of the parties because it is already extinguished. Under the Civil Code of the Philippines, there are six general modes to extinguish an obligation. And these are payment or performance, loss of the thing due, condonation or remission of the debt, confusion or merger of rights of the parties, compensation or set off, and novation. We will talk about each one of these modes to extinguish an obligation. Let's start with payment or performance. In civil law, the words payment or performance are oftentimes being interchanged in the sense that the words payment or performance refer to delivery of money, which is the object of the obligation, or performance by the obligor in any other manner of the obligation in favor of the obligee. For payment or performance to be a mode to extinguish an obligation, the following requirements must be observed or must be present. First, insofar as the delivery of money or the object of the obligation is concerned, the debtor making the payment or performance must have the free disposal of the thing due, meaning that he either has the ownership of the object of the obligation being delivered, or she has the authority to deliver the object of the obligation to the creditor or the obligee. The debtor or the obligor must also have the right to dispose of the thing or the capacity to alienate. When there is delivery to the creditor or to the obligee, that means that the debtor is already alienating or disposing of the thing, depending on the tenor of his or her obligation in favor of the creditor. Therefore, in making the payment or performance, the debtor or the obligor must have that right to dispose or capacity to alienate the object of the obligation. For payment or performance also, to extinguish an obligation completely or fully, there must be a complete or full payment or performance of the obligation. Meaning that if the debtor owes the creditor 10,000 pesos, he cannot extinguish the entire obligation of 10,000 pesos if the delivery or the payment of money is not complete. Otherwise, there will be only a partial or an incomplete payment or performance of the obligation that will not extinguish the entire obligation. We have studied already in the past that partial payment or incomplete performance of an obligation gives the creditor the right to accept or reject the performance for the payment or performance not being complete. And it is the prerogative of the creditor to accept or reject the partial or incomplete performance of the obligation. The general rule is in order to completely extinguish or fully extinguish the obligation, the payment or performance must be pertaining to the entire tenor or object of the obligation. In other words, payment or performance must be complete. However, there are exceptions to the rule, particularly in situations wherein the debtor cannot anymore perform the obligation completely or entirely for reasons not attributable to his or her fault. In other words, there must be a good reason, lawful and valid reason, on the part of the debtor why the debtor cannot anymore completely or fully perform the obligation in favor of the creditor. We call that a substantial performance in good faith. The second exception is in a situation wherein the creditor has categorically accepted the partial or incomplete performance of the obligation by the debtor, regardless as to whether he or she has a valid reason or none at all. Because in this particular case, the creditor is waiving his or her right to reject the partial or incomplete performance which is not in good faith and which may be not substantial in nature. In that particular case, the acceptance made by the creditor and giving no or raising no objections on the partial or incomplete performance by the debtor will partly extinguish the obligation by way of payment or performance. There are special forms of payment under the law. The first special form of payment is what we call as dasyon and pago or adjudicasyon and pago or simply dacion in payment in some law books. Dasyon and pago presupposes the fact that there is an existing monetary obligation. What's the meaning of that? There is a pre-existing obligation to pay in terms of money or to pay money. However, in dasyon and pago, the debtor has agreed with the creditor that instead of paying the original pre-existing obligation in money, the debtor will simply alienate or deliver to the creditor an equivalent property, which will be a substitute form of payment for that pre-existing original obligation in money. And when the creditor agrees with that kind of substitution of the obligation in money with a property, then that is considered as dasyon and pago or dacion in payment, which is a special form of payment because the original obligation was not extinguished through the payment or performance of the original object in that obligation, but it was extinguished through the delivery of a different kind of object, which is instead of money, a property. But nevertheless, in the dasyon and pago, it is important for us to understand that the obligation is still extinguished, but through that special form of payment, which we call as dacion in payment. The second form of payment, which is special in nature, is what we call as payment by cession. Payment by cession. In payment by cession, the debtor is already in a state of insolvency or bankruptcy. And his assets are no longer enough to cover all his liabilities. What the debtor does in payment by cession is he abandons all his or her remaining properties to the sole creditor or to the creditors for the creditor or creditors to sell these remaining properties abandoned to him or to her as payment of the original obligation of the debtor who is now in a state of bankruptcy or insolvency. And the sale proceeds of the remaining properties of the debtor shall be considered as full and complete payment of the obligation of the insolvent debtor to the creditor who accepted the abandonment of all the properties of the debtor as payment of the remaining obligation. That is a special form of payment because actually the obligation of the debtor is not fully and completely paid for because he is already in a state of bankruptcy and his assets are no longer sufficient to cover all his liabilities. It's only that he abandoned already his or her properties to the creditor and the creditor agreed. That agreement is what we call as payment by cession, which is a special form of payment that will extinguish an obligation. The third special form of payment is what we call as tender of payment and consignation. Tender of payment and consignation. Why do I emphasize the word "and"? Because in this special form of payment, there are two special phases or actions or processes that the debtor must comply with in order to extinguish the obligation fully. First, tender of payment. Tender of payment simply means that the debtor is offering payment to the creditor. But the creditor without, take note, without justifiable cause or reason, has refused to accept the offer made by the debtor. That is the first part or process or phase in this special form of payment. And when the creditor refuses without justifiable cause the tender of payment made by the debtor, there is no extinguishment yet. If there is no extinguishment yet because the second phase is not yet complied with by the debtor. There will be extinguishment only if after the tender of payment, consignation will be made by the debtor. What is consignation? Consignation under the law refers to judicial consignation for this special form of payment, where the debtor is, after making the tender of payment, is required to deposit the payment in court. So that when deposited already in court, regardless as to whether the creditor has withdrawn the deposited amount or payment in court or not, as soon as the debtor makes the judicial consignation, the obligation of the debtor in favor of the creditor is considered under the law as automatically extinguished by special form of payment called tender of payment and consignation, which is judicial in nature. The fourth special form of payment is what we call as application of payments. Application of payments takes place when there is only one debtor and creditor. And the debtor has several debts in favor of the creditor. And the debts are of the same kind. What do I mean by of the same kind? If debt number one is money, debt number two, and the remaining other debts must also be in terms of money. If debt number one is in terms of a specific object, like for example, a laptop, debt number two, debt number three, and the other kinds of debts must be also in terms of a laptop of the same kind. And all the debts that we are talking about here must already have become due and demandable, or the obligations of the debtor have already matured. When all these requisites for application of payments are present, then the debtor may choose. The debtor may choose from the several debts which particular debt shall be extinguished. Which particular debt shall be extinguished, provided that the payment or performance made by the debtor is sufficient, full, and complete enough to extinguish the debt chosen by the debtor. However, with respect to the debts that are not chosen by the debtor and for which the payment or performance made by him, which are, I suppose, partial, cannot cover the debts which are not chosen by the debtor, then this cannot be extinguished. Only those that are fully covered by the payment or performance and chosen by the debtor shall be extinguished under the law through the special form of payment called application of payment, because the debtor will choose to which particular obligation will the partial payment, not covering all the several debts, will be applied. Remember, it is the choice of the debtor and not the choice of the creditor, unless the parties have agreed mutually that it will be the choice of the creditor or somebody else. Let's go to the second type of obligation, second type of extinguishment of an obligation, which is loss of the thing due. We had already extensively discussed this in our previous lessons, particularly when we talk about genus nunquam perit or peruit, when we distinguish a generic thing from a specific thing. And for this to be a mode to extinguish an obligation, the cause of the loss must be a caso fortuito or a fortuitous event. And the loss of the thing must be beyond the control of the debtor. And he committed no fault in the loss of the determinate thing. In this particular case, while the obligation of the debtor in favor of the creditor is extinguished by loss of the thing due by caso fortuito, the creditor shall have the right to be subrogated. Subrogated means that the right of the creditor will arise from the right of the debtor to go after the third person who caused the loss, if any. So for example, whoever robbed the determinate object from the debtor that resulted to the extinguishment of the obligation of the debtor, while the debtor is exempted already from the performance of his obligation in favor of the creditor, because of extinguishment, the creditor will be subrogated into the rights of the debtor to go against and go after the person or persons responsible for the fortuitous loss. Because a fortuitous loss is something that is beyond the control of the debtor. So that is the concept of subrogation on the part of the creditor with respect to the right of the debtor to go against the third person who caused the fortuitous loss. The next type or mode of extinguishment of an obligation is what we call as condonation, and the verb is condone, or remission, or remit, to forgive, to waive your right against the debtor, is condonation or remission. It is actually in the form of a donation, and we studied in the past that when there is donation, there must be acceptance by the donee of such donation. Otherwise, the donation will not be valid. Since condonation as a form of extinguishment is a form of a donation as well, gratuitous because the creditor is not expecting something in return, there is an equivalent requirement that in extinguishment of obligation through remission, the debtor or the obligor must expressly or impliedly accept the remission or the condonation of the obligation. The reason for this is because the law does not want people to have utang na loob in favor of another person without his or her consent. Remember, this is gratuitous donation or condonation. It must not also deprive the right of the compulsory heirs. We talked about inheritance already in the past. The compulsory heirs under the law who have reserved rights of inheritance from the creditor, meaning that the right of the heirs of the creditor who will make the condonation or remission must not be diminished or deprived by such kind of condonation made by the creditor. And the creditor cannot condone an obligation if the obligation of the debtor has not yet become a mature obligation or is not yet due and demandable. The condonation or remission so as to extinguish an obligation because it is a form of a gratuitous donation is also required to conform or comply with the forms or with the formalities, the rules on the nation. Like for example, if the obligation to be condoned is more than 5,000 pesos, it must be in writing. Otherwise, it will be void, just like in donation. If what will be condoned is the delivery or performance of an immovable or a real property, the condonation must be reflected in the public document. Otherwise, it cannot be valid as well. The next mode to extinguish an obligation is confusion or merger. Confusion or merger. The creditor and debtor in this case have become one person. The right of being a creditor and the obligation of a debtor had been already merged in one person. Let's have an example. If A is obligated in the amount of 10,000 pesos to B, and B is obligated in the same amount of 10,000 pesos to pay C. C is likewise indebted to A in the amount of 10,000 pesos. If you will notice, if A will pay B, C, and pay A again, the 10,000 pesos will just rotate among A, B, and C. And in this particular case, all of them can be considered as creditors and debtors of one another. Similarly, if A borrowed 1 million pesos from B, and then B borrowed 1 million pesos from A in separate occasions, A and B have likewise become creditors and debtors to each other. And collecting 1 million pesos from one will entitle the other to collect 1 million pesos again also from that person. Therefore, there is no need for A to pay B and B to pay A because there is already confusion or merger. The obligation is already extinguished when this happens. But take note, the merger must pertain to a principal obligation. What is a principal obligation? A principal obligation, as we had studied before, is an obligation that can stay and stand on its own. It does not need other obligations in order to be valid. Example, if I loan is a principal obligation. If I will borrow from you 1 million pesos, my loan from you is a principal obligation because it can stand on its own. If I borrowed 1 million pesos from you, and then in order to secure the fulfillment of my obligation in your favor, you required me to give you a collateral, either a pledge or a mortgage of my property to ensure that I will pay you back. And if I will not pay you the 1 million pesos, you will foreclose or get my collateral, either in the form of a pledge or in a mortgage. The collateral, the pledge or the mortgage, they are considered as accessory obligations. Why accessory? Because the collateral cannot stand on their own. The reason why pledge and mortgage contracts are entered into is only for the purpose of supporting or securing the payment of the principal obligation loan, which is loan. Therefore, pledge and mortgage as collaterals cannot exist without the loan. In our example, the loan is a principal obligation and the pledge or mortgage are considered as merely accessory obligations. Now, if the merger or confusion pertains to one, a principal obligation, and two, an accessory obligation, there can be no confusion or merger. Because the accessory obligations are dependent on the principal obligation and they cannot automatically be extinguished by reason of confusion or merger. And the confusion or merger must refer to the entire obligation. You cannot partially extinguish an obligation by confusion or merger. If I owe you 1 million pesos and you owe me 700,000 pesos, it cannot completely extinguish the obligation by confusion. The most that could happen could be a partial extinguishment of the obligation. But the obligation remains insofar as the balance is concerned, the one that is not covered by merger or confusion. The next type of extinguishment of an obligation is what we call as set-off or compensation. There is compensation when two persons in their own right become creditors and debtors of each other. If in their own right they become creditors and debtors of each other, there is compensation. Just like in the previous example, when I borrow 1 million pesos from you and you borrowed another 1 million pesos from me, we are creditors and debtors of each other. There is already compensation. While confusion and compensation may be very similar to each other, strictly speaking, in compensation, there are only two persons involved, the creditor and debtor, who are creditors and debtors in their own right of each other. It is distinguished, strictly speaking, from confusion or merger when there may be more than two persons involved. And because of the cycle of being creditor and debtor, one person has become a creditor and debtor of himself. While compensation and confusion may be similar to each other, confusion in this case may refer to more than two persons who have been creditors and debtors of each other. And the right of being a creditor and debtor has fallen on one particular person. In compensation, there are two persons involved strictly. What are the kinds of compensation under the law? If compensation is mutually agreed upon by the creditor and debtor, then it is considered as conventional or voluntary compensation. If compensation is mandated by law, by a provision of law, then it is considered as a legal compensation. An example of this is in a contract of agency, when a principal has appointed an agent to represent himself in transactions with third persons. An agent generally is entitled to compensation for the services that he or she will render in favor of the principal. Let us say, for example, that the agent and the principal have agreed that the agent shall be paid by the principal 100,000 pesos for the services. The agent was able to collect from one of the clients of the principal, and the client paid the agent 100,000 pesos for the principal, but collected by the agent representing the principal. In that particular case, after the required accounting of the agency transactions made by the agent, the principal need not collect from the agent the 100,000 pesos because the agent is anyway entitled to 100,000 pesos as payment for his or her services, because that's provided by law in the contract of agency. That's legal compensation. But that is only after the accounting of all the transactions made by the agent on behalf of the principal, insofar as the third persons are concerned. Judicial compensation is when compensation is dictated or required by our courts of justice after due process and after the hearing of a particular case. The last mode to extinguish an obligation is called novation. Novation refers to total or partial extinguishment of an obligation by modifying the following aspects of an existing obligation. Okay? So what are these aspects in an existing obligation that will be modified by innovation? Let's look at number one. Changing the object or the principal condition or conditions of an existing obligation. It is also called as real or objective innovation. If my original obligation to you is to deliver a determinate car, that is the principal object or condition in our obligation. The reason why I will deliver to you the determinate car is because you paid me the purchase price of 5 million pesos. Later on, we agreed. We agreed to modify the conditions, the terms and conditions of our sale as an obligation. And we agreed, you as my creditor and me as the debtor, that you will still have to pay me 5 million pesos, but I will have to deliver to you a different determinate car. A different but determinate car. Let's say instead of a car with plate number ABC123, I will deliver to you a determinate car with plate number XYZ5678. Is real or objective novation. Why is this considered as a form of extinguishment? It is because the old obligation is extinguished. And because of the modification of that term or condition of that original obligation, a new obligation is created. And that is the delivery of a new, different, determinate car with plate number XYZ5678. Let's go to the second type of novation. Personal or subjective novation on the part of the debtor. In this particular case, there is a substitution of the party to an obligation. There is a substitution of a party to an obligation. Look at the second and the third types of novation. In the second type of novation, the one being substituted is the party debtor or the obligor. In other words, the debtor is being replaced by another person who will perform the same obligation in favor of the original creditor. If I have an obligation to deliver to you a determinate car, later we agreed that instead of me delivering to you the determinate car, it will be the buyer of that determinate car from me, let's say X. With the consent of X, you as the creditor and me as the original debtor, there is novation. Because there is a substitution of the person of the debtor by another person. But that presupposes the fact that all the three of us will agree on the type of novation. Same with number 3. In number 3, it is the creditor being substituted. Again, it presupposes the fact that the original creditor, the new creditor, and the original and the debtor have all agreed that there will be a substitution not of the debtor but of the creditor. We call this, instead of substituting the person of the debtor, as subrogating a third person in the right of the creditor. Personal or subjective novation on the part of the creditor. And the last type of novation is what we call as mixed, or in some, according to some authors, eclectic novation. Mixed novation or eclectic novation is a combination of real or personal novation. There is still a novation because the old original obligation is modified to create a new obligation where there is in mixed both a real, a change in the principal terms and conditions, and a substitution or subrogation. Mixed or eclectic. Okay, so that completes our discussion of obligations, and I'll see you during our synchronous classes. Thank you.